It is June 13th of 2026, and this is the Court Gallery. Ever had a bad breakup? Well, these two each other of stalking and demanding a judge keep them apart. Then, in a completely different case, you have an alleged victim who shows up and asks the judge to drop the no contact order against her and her ex for a heartbreaking reason. And finally, stick around for the woman whose car repair dispute lasted so long, the shop had it towed and auctioned off, leading to a small claims battle where the judge was not having any of it. It's a wild and weird day from the state of Washington, ladies and gentlemen, and it all starts right now.
Jonna Wesley, Amy Lamerson. No, I'm going to swear you in. Ms. Wesley and Ms. Lamerson, if you'd raise your right hands, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes.
Thank you. You may be seated. Go ahead and have a seat.
Your Honor, may I ask?
I'll come to you in just a moment. All right. Ms. Wesley, you and Ms. Lamerson were in a dating relationship. Is that right?
Yes.
All right. And you've never resided together?
No. No, I saw that got checked off, but I didn't check it. I think someone just marked the wrong box. And I also found last night there was one of my letters that got put into the pet category. So, yeah.
That's petitioner.
Pardon?
Said it stands for petitioner.
Oh, okay. I thought it meant an actual pet. I gotcha.
No. No, you're the petitioner in this matter. Okay. You said that Ms. Lamerson has yelled at you, screamed at you, mostly those things, and has said what you believe to be inappropriate things towards you, demeaning things. Is that a general summary of your concerns?
No. I was attempting to call 911 and she knocked my phone out of my hands, so I wasn't able to do so. I called after the fact. She was also standing at my front door shaking my door, so I finally let her in, and she was asked to leave by me 3 times and was still in my home. And then my roommates came downstairs and forced her out the front door, just kept walking forward and told her she needed to leave.
Okay. And the document you filed is your statement or statement of whom? It was unclear to me because it's not signed.
I'm not sure which document you're referring to.
The one that you said was the pet exhibit.
Oh, that is a statement from my roommate, and she did sign it up in the top corner.
Okay, is that Sierra?
Correct. And the other roommate's name is Joy, so she refers to Joyous in her
Yeah,
letter.
okay. All right.
They're a couple that live upstairs.
Okay. And Cal is, according to this, is Ms. Lamerson, is that right?
It's my name.
Yes, she goes by Cal, which I'm assuming stands for Carol Amy Lamerston.
Okay,
It's actually my gin, sir. It's about,
okay,
she,
so that's, okay,
I'd like to, I know you're gonna give me a shot, so
all right.
be patient. And I don't know her as John or Wesley either.
No, I go by Jonna Morton, which is my maiden name, but I have never changed my last name from when I was married.
Okay,
So legally, it's Jonna Wesley.
all right. And you want to go by Ms. Lamerson, Mr. Lamerson? How do you want to be?
Thank you for asking, sir. Ms. is fine.
Okay, so Ms.
I use
Lamerson.
she, they pronouns, so
Okay.
you're good. And you can reference me as my legal name, Amy, or Cal is what I
I'll
go
just
by
call you
with
Ms.
my
Lamerson.
state government job.
Okay, so go ahead.
So I object to the no contact order because I have no desire to be around her and I've never threatened her. There's a, I originally met her almost a year ago. May I refer to my notes really quick and I'll make it
Yep,
quick, sir?
that's fine.
Back in August of 25 is when she first reached out to me through a Facebook dating. And I am new here. I work for the government and I work from home. So I was trying to make some friends. She's one of 5 people I connected with and made friends with back in August. I learned then that she had a October of 23 anti-harassment stalking case. And I have my master's in social work and I work in administration. I worked in administration for the Department of Corrections. So that made me very nervous. And I told her I couldn't hang out with her anymore. And she blocked me back then. And then she reached out to me in November and said she had no hard feelings and she'd like for us to be friends. I'm a forgiving person, and so I wanted to try to be friends. My nervousness, just so you know, I do have dysautonomia, and I have a physical disorder that I'm out on disability for right now that I'm addressing. So my shakiness and stuff is just my trauma and anxiety. So that's all it is.
You're not alone coming into a courtroom feeling that way.
I get that. Yeah. I'm out for compassion fatigue because of my many years of serving serious and persistent mental illness. So I've seen it a lot and I tend to call things out when I see them and that makes people uncomfortable. So my testimony is, we met up in August. I learned of her past charge of anti-stalking and DV. That made me nervous because I have a prior from 25 years ago that I turned my life around and became a social worker and rebuilt my life and my character. And that's been my whole existence. If you Googled me, is me working as a public servant, helping others in vulnerable populations. And so on the 20th, I want to make it sure I keep it all. I reached out to her on April 22nd and told her I was finally selling my home. And she said, do you need any help moving since you have this connective tissue disorder that's got you on disability? I said, I'm looking for friendship. Yeah, I would love your help. I don't have any support other than my realtor. That was on April 22nd. I hung out with her a few times in May. I learned that she overdrafted her account. I felt bad for her. I gave her $300 to get her account in the right. And I said, it's okay, Jonna, we all go through hard times. I took her out to eat. I always paid because she said, I don't have money in my budget to go out to eat. I invited her to a concert. We went to a local concert together. I was having bad anxiety one night and she offered me to stay the night at her house just as a friend of comfort, and I did. When I moved out of my home, I sold a very nice home and I'm currently staying in my camper until I can figure out where I want to be next. All these things, it's like, when I learned about her old charges and I found 5 different aliases and she showed me 4 different engagement rings in a matter of a week hanging out with her, it started making me nervous. Like maybe she was just after me because I just sold a home and made a profit. Because there's been other issues that I've seen like this. And so when she invited me on, like the date is wrong on the roommate's testimony. That event happened on May 25th. I was on Vashon Island, staying in an Airbnb the 23rd and the 24th. I got off of Vashon Island with a voicemail from Jonna inviting me over to be friends. She's sorry she hurt my feelings. She's sorry she offended me. Invited me over to her home and invited me to go to her hometown, which is in Menlo. I'd never been. I'm from Ohio. And we drove down to Menlo, and on that, before we got in the car, I said, I'm nervous. I don't want to argue with you. I don't want to have no problems. And she goes, I'm sorry, Cal. It was me. I'll be sensitive to your emotional state and your anxiety. We get in the car. We get down to Menlo.
Oh, I'm sorry. You drove from here to
Yeah,
Bay Area?
She invited me to her home. I parked my truck in front of her.
In the Bay Area?
Excuse me, the Bay.
Menlo, California?
No, Menlo. Minelo, it's a little town out by PL, I think. I don't know. It's Lewis County.
Okay.
Yeah, no, just to drive down to a cemetery local about an hour away.
All right.
I like old cemeteries, and that's why she invited me, so I could see the dates on the headstones. That's how I got in her car that day, is what I'm trying to explain. I don't want to confuse this. I'm sorry. I have ADHD, so I want to make sure I keep it all straight. At the cemetery, I gave her private time with her family, but then I suddenly got a gut feeling because I was so far away from the car. I don't know her that well. She could leave me out here and I don't have any phone service. So I get back in the car and she started saying how we were going to drive by her mom's house and her mom doesn't like her. And I said, your mom's sitting outside. I'm not comfortable driving by your mom's house. I'm trying to explain to you that there's some stalker behavior. She's claiming she's talked to an ex of mine. I seen the documents in the court thing this morning. There's no ex of mine here. I have an ex-wife that I divorced in April of 23. We are on good terms. We came here from Ohio together. Any ex-girlfriends I have, I'm on speaking terms with. And the one person I know she tried to reach out to contacted me and said she's very concerned because this woman's trying to paint a case. And she said, I played along with her. And I said, well, I think I've read your messages. And she goes, Cal, I'm worried that this woman, there's something wrong with her. She worked at Department of Corrections with me, the person I think that she's claiming she has text messages with. So when I look at all this situation, and I did get advice from my attorney, he said, this is civil, not criminal. Just go in and tell your testimony. Tell the 5 aliases. Mention the Cottonwood County case of false imprisonment. She held somebody against their will, a partner that she was engaged to, and the court records that say this. And she is currently under the DV MRT program. I'm transparent. She knew I had another case and it was dismissed for me to do that same DV MRT class because there was no evidence that I did what was the other allegation. She heard about this and I feel like she's jumping on something. When I was in her home that day, her roommate, I was the one that asked the roommate to come downstairs for the witness. And then Jonna ran up the stairs and said she was scared of me. I said, is a liar. There's something wrong with her. She just had me in her car. She drove 80 miles an hour and told me to get out. I wanted to get out on the I-5 somewhere in Chehalis and Centralia. When I called the police, as soon as I got to her house, I called the Thurston County Sheriff and they said it didn't happen in Thurston County. What county? I said, I don't know. I got to look it up on a map. It's either Mason or it's Lewis. He said, well, where does she live? I said, 237 Sherman. He said, that would be Olympia Police. We will have them call you back. Olympia Police called me back that day, the 25th it happened. I told them everything. I called my attorney. I called my diversion officer immediately. They all said, Cal, you did not violate. The police said I should file an anti-stalking order because she had called 2 times before that on me while we were friends. It was like she was trying to set me up, is how it feels, because the only altercation was in her car. And the part where she says I knocked her phone out of her hand, her phone sits in a phone thing up on her dash and it falls out all the time. I've seen it happen several times as she was driving me around. Because of my anxiety, I don't drive a lot. And as I said, I'm out on state disability right now from my state public service job because my nerves are shot. I have dysautonomia and I've just seen a lot in my career. And so I cry a lot. And that makes people uncomfortable when I cry. And then they think I'm crazy. And I'm not crazy. I don't understand the lies. I've lived a life of integrity since my mistake in 2000. You could read the judge's letter from that case. I have turned my life around. And people now, I feel like this woman knows I've got a little bit of money. And so no police officer would take her case. They said it's not DV because I only hung out with her. And when she says I have her back gate key combination, it was because I hung a tarp for her in front of her trash cans. I was doing service goodness for her, with her as a friend, and she helped me move. So me choosing to not date her because it made me uncomfortable that she was stalking her mom's home, that's why the argument happened. I said, you're driving by your mother's and she's asked you to not talk to her. I'm not comfortable being in this car. I want to go home. And then she took me down several country roads and it took 5 hours to get home from Chehalis. And she didn't take the most direct route to her house to get me out of her car. She drove all the way around to Cooper Point and back some back roads. I said, what are you doing? Please let me out of your car. And as soon as I started to get out, I said, can I have my belongings in your house? And it's not clothing like she states. It's these expensive glass balls that when I moved, I didn't want to put them in my storage unit. And she said she'd hold them for me. I'm not asking for anything back, sir. I just know I'm never going to contact this woman again.
Okay, thank you.
Thank you.
Ms. Wesley?
My goodness gracious. Where do I even begin? Goodness. Well, we got sworn in, so yeah, at least someone will be telling the truth here. My case right now has an attorney in Minnesota. That was a false allegation. I am currently suing the state of Minnesota, and I finished that class. I am now training to teach DVT MRT. So let's get that out of the way. Also, that is true. I did have a charge. I lived in the state of Minnesota for 11 days with a woman that I met. And yes, that was all false, which absolutely has nothing to do with this. Let me see what else. Her screaming at me, her trip to the Whidbey Island or which island ever she mentioned, that was something she invited me on. She immediately starts screaming at me in my car because I checked a message wondering if it was from my daughter who'd recently had a miscarriage. And she screamed at me that I asked for 24 hours. You can't even stay off your phone for 24 hours. And I said, oh no. So I turned around and I said, I'm not going now. So she took someone else on that trip. Then out of the goodness of my heart, I forgave her and I thought, okay, maybe this is an isolated incident. And I did take her to Menlo to the cemetery. It was Memorial Day weekend. And she had told me she does like seeing old headstones and such. And I said, well, there's tons of them there. I didn't take the back roads anywhere. She wanted to stop at another cemetery that was just outside of Chehalis. And I said, yeah, we can take the Chehalis loop home. We stopped at that cemetery. Then we headed on. We got onto I-5. Something else pissed her off. And she was screaming at me, shut the fuck up, Jonna. The top of her lungs in my face. I'm trying to drive on the interstate with Memorial Day traffic. My phone was in the thing, and I said, oh no. And I went to grab it. I said, I am not doing this. And then she knocked it out of my hands because I told her I was calling for law enforcement. And then she starts taking her seatbelt off. I said, if you don't want to be in this car, I can drop you off, but please put your seatbelt on. And I was not going 80. I was going 70 or 75 because it's 70. My speed, what's it called when you set your speed? But it's 70 miles an hour, you know, the Chehalis. When I got home, she wanted things out of the house. She had changed into shorts before we left. And I said, I will go in there and get them. Oh no, she was up on the porch, yanking at my door to get in. I don't live in a neighborhood where I've ever seen law enforcement. So I wasn't about to have that happen. So I let her in. And then she's in there, John is a liar, blah, blah, blah. I went up the stairs. I said, can you guys please call law enforcement? And they came down, and I asked her to leave out of my house 3 times. She's still in there wandering around. And my roommates just kept walking. You need to leave. We're calling the police, and walked her out the front door. As far as the glass orbs, she's welcome to have them back. I was not holding on to them. She gave them to me the day I was helping her move. She gifted them to me. If she would like them back, that's fine. I don't have a problem with that. I have not stalked her. I don't stalk my mom. I told her, I said, I'll show you my high school and my childhood home. And the high school's here. I lived a half a block from the high school growing up. We drove by my mom's house, and I was very sad because my mom and I don't have a relationship. And she said, oh, your mom was sitting outside. I said, she was? I didn't see her, but we kept driving. We didn't stop. I don't stalk my mom. She lives in Menlo. I live in Olympia. I mean, yeah, this is a performance. She was recently in Superior Court for strangling a woman. And these people I've been talking to, one reached out to me, scared to death because I had brought Cal's name up. And she said, oh my God, I went on a date with this woman, and I have never been scared as I was in my life going on a date. And then the other gal told me to please be careful, stay away from her, call the police if I needed. And that's that. So, yeah, I just want to live my life in peace. I'm sorry that I ever met this woman. She has a lot of mental health issues. She got fired from DOC for the strangulation case. So she's not out on disability just to be out on disability. She was let go because she allegedly tried to strangle the last person before myself. So knowing this from this last person, I wasn't there. I don't know if that happened or not. But the gal that when I brought up Cal's name, she's like, oh my gosh, I don't know if I want to hang out with you if you're friends with her, because I was scared to death when I went out on a date with that woman. So that's number 2. And this other gal is number 3. So yeah, there's that.
All right. Thank you.
Is there anything else you'd like to hear from me, Your Honor?
I don't think so. The answer should be no, I don't need to hear.
Thank you. May I ask a question while you're looking at that?
You may ask a question. Go ahead.
If I need to file an order against her now that I found this new information that she's reaching out to people in my life on Facebook when I have her blocked, and she's slandering me it's not two people, it's one, because the woman reached out to me and said she's highly uncomfortable and that I should file for slander orders. And so should I do that through the court and get that information today?
There is no such thing as a slander order.
Or
Fact.
anti-harassment, I guess.
Well, it's anti-harassment, but it has to be threatening. The court does not tell people to clean up their language when describing somebody else. So people can say all the bad things they want about somebody. We don't have any ability to regulate that.
That's why I
I
didn't
am not
follow.
trying to harass anyone. These women are warning
Okay,
me.
all right. Yeah, I think I have a sense of what's going on here, so
When the
I think I've heard
officers-
enough. I was just answering a question.
And for the record, I do not want anything back. I want no contact.
All right, so listening to the two of you, I think one thing jumps out at me, which is that neither one of you wants the other to have any contact with you. So that's very clear to me. And the events that happened on the 24th or 25th, depending on which day it was, and I don't necessarily find that the date is determinative here in my evaluation of the facts in this case. Breakups of relationships can be, and whether, even without regard to the depth of the relationship, breakups in a relationship, friends or partners or whatever that may be, can be hard, and people react in certain ways. And that's my perception as to what's happened here. So I'm not going to enter a protection order in this case, but I want to make a little record that it's very clear to me that you each are asking the other not to have any contact. So going forward, I would expect you to each comply with the other's request, and to the degree that you don't, the other is welcome to file a petition with the court saying, hey, we had this whole hearing. We made it very clear to each other that we don't want to have contact, and yet in spite of that, there's been contact. So I just want to make a record of that. We can deal with this down the road if somebody feels like they need to, but I'm hoping that you both realize that this is not a relationship that's going forward, and you each want to move in your own directions away from each other. And that seems entirely appropriate.
Yes,
So I'm going to enter a denial that reflects that, and hope the two of you can live up to that. And Ms. Lamerson is in the courtroom. We'll give her a copy of this. And Ms. Wesley, do we email it to her, or she gets it on file? It'll be on the website later today if you want to get a copy of it.
So is it decided there's no more questions or anything?
Yeah, Yeah, I've decided it.
Hmm.
So
Fantastic.
I've given
Okay.
you the basis of my ruling and go forward and hope the two of you not have any further contact with each other. All right. Thank you both.
Thank you.
You can let you know when it's ready.
Okay, thank you.
Excuse me, Your Honor, can my mother go to the bathroom?
Sure. And Mr. Fosnot, why don't you come on up and have a seat right here?
Yes, sir.
And Ms. Wagner, if you'll activate your audio and video, please.
Grant Morris. Grant Morris.
Good morning, Your Honor. How you
Good
doing today?
morning. I'm doing well. How are you?
I'm doing great.
All right, one moment. Let me get your case out. So it looks like you had a prior deferral, so it not eligible for that. Let me pull up the actual infraction. Be nice if this was alphabetical, but that's fine. All right, so we have a speeding 5 miles over the speed limit with an actual speed of 82 miles an hour. I've had a chance to review the officer's narrative or deputy's narrative, or trooper's narrative, excuse me. So what would you like to tell me for the contested infraction hearing today?
No, wow, because he told me I went 75 over, so he didn't tell me 82.
You said you went 75 over?
Yep,
Or you were,
yep. I was going 75. That's what he told me.
okay.
So what happened when I was the Total River rest area, I was traveling southbound. I was on cruise control. I was going up a hill, and then where he was parked was right after the exit of the rest area.
Mm-hmm.
And then the way I looked was my car, when it came over, it accelerated. And then that's when he pointed at me and he lit me up. So I was getting over to get off the next exit because I had to use the restroom.
Okay.
So I missed that exit. So I was traveling to Portland, and then I was doing a project there, and then so I tested it again at that same spot with my car, and it does go over, accelerates over the speed limit. So when I'm on cruise control, when you go up a hill and then when you go down, it accelerates. So that's where he got me. So
So you're saying
I
the
didn't
cruise,
argue.
you're saying the cruise control got you to the 82 over
Yeah,
the hill coming down?
no, not 82. So like either like 5 miles or whatever.
Yeah.
I didn't go 82. I don't feel like I went 82. I don't feel like it accelerated 82.
Okay.
I feel like it, accelerated to like 5 miles over the speed limit. So he told me I went 75. So
I think he cited you for 5 miles over the speed limit, but your actual speed was 82.
I don't believe my actual speed was 82 because he told me 75.
Okay. So looking at the trooper's narrative, we did have this, it was a LiDAR L1682. It did showing this testing before and after at the end of the shift. Looks like he got an initial speed estimate for your vehicle and then had the LiDAR reading on your vehicle. He's an unobstructed clear view of your vehicle. It's 100% certain that the LiDAR reading was obtained from your vehicle, and they obtained a reading of 82 at a distance of 684 feet in a 70-mile-per-hour zone. So I have his visual estimation of your speed and the LiDAR reading of your speed at 82 miles an hour. So at this point, I'm going to find the infraction committed. Your history is a bit concerning. We've had multiple years of speeding tickets and other infractions. So I'm going to just find it committed as it's currently in the full amount, as it's a $119 ticket. So you will have you'll have 60 days to either pay this in full or set up a payment plan. You can either do that online or in person.
How can I contest this?
This is the contested hearing.
Yeah, how can I appeal it?
Yes, you can appeal. I will check the box. So here, I will read you your rights. Because this is a contested hearing, you have the right to appeal this court's decision to the Cowlitz County Superior Court. You must file a written notice of appeal with the district court clerk within 30 days from today. You must also serve a copy of your notice of appeal on the prosecuting attorney or city attorney. The district court clerk will give you a notice of appeal form at your request. If you do not file your notice of appeal within the time allowed by law, you lose your right to appeal. And this paperwork will be mailed out to the address that we have on file. It has all the information. So the payment options, either pay in full within 60 days or set up a payment plan, my ruling, as well as your notice of appeal rights. Okay,
All right,
do you have
thank you.
any further questions?
Nope, so I'll get all this in the mail?
Yep, it will be mailed out to the address that we have on file for you.
All right, thank you.
Thank you. Have a great day.
Hello?
Good morning. Is this Mr. Sturgeon?
Yes.
All right. One moment while I pull up your case. So we have speeding too fast for conditions. I'm not showing any prior deferrals. Are you interested in the deferral program?
No.
Okay, so let me pull up your case. All right, so speeding too fast for conditions. I've had a chance to review the trooper's report. What would you like to tell me about that day?
Your Honor, before this matter proceeds, I move for immediate dismissal. I object to this hearing going forward because the court is forcing me into a Zoom appearance despite my clearly stated religious objection. I previously informed the court that using Zoom violates my sincerely held religious beliefs, and I requested an in-person hearing so that I could appear without being forced to violate my conscience. The court has not properly answered or ruled on that religious accommodation request, and my other pending motions have also gone unanswered or unresolved. Proceeding today under those circumstances places me in a position of either violating my religious beliefs or being denied meaningful access to the court. That is not due process. I am appearing under protest only to preserve my rights. I do not consent to this Zoom proceedings. I do not waive my religious objection. I do not waive my pending motions. I object to the court taking any evidence, testimony, or argument before addressing the violation of my religious rights. This is not a minor procedural issue. The court was put on notice that this hearing format burdens my religious conscience, yet the court is still attempting to proceed without first providing a lawful ruling, written explanation, or meaningful accommodation. Forcing me to participate in a process that violates my faith while ignoring my motions prejudices my defense and denies me fair access to justice. For these reasons, I respectfully move that this case be dismissed immediately for violation of my religious rights, denial of due process, and failure to rule on my pending motions before attempting to proceed.
Okay, so I'm looking through the court file because I do see a few motions to continue our motions to appear in person, and I do believe that the court has already ruled upon those requests, and has denied them. I'm pulling up looks like Judge Pro Tem Nelson granted your continuance request. That was submitted April 20th. It was set over to today. Your motion for an in-person hearing was denied. And a motion for subpoena, you will need to submit a subpoena for the courts with a signature and pay for service of the officer. So it looks like there's already been rulings made on those motions, so I haven't heard anything different from what is written in your motions, particularly I
Your
think the
Honor,
one file. Excuse me, I let you speak, so please do not interrupt the court. So I had the document submitted April 20th, basically listed out the basis that you cited in court today for the motions. So I haven't heard any change. I'm going to continue the denial of their request, and we are here today for the contested hearing. So we can proceed today with the contested hearing.
Is the officer here?
Did you subpoena the officer?
I did subpoena the officer. I have a proof of service, and I also sent that to the prosecuting office. Submitted it to the prosecuting office.
One moment, please. Did you subpoena the officer themselves, not just the prosecutor?
I subpoenaed the officer.
By what service?
In person.
You personally served him?
I gave it to the department, and they served on my behalf. I was told that was the procedure.
What department? Because I have a certificate of service that was filed April 24th, and it says other for certificate of service, but it doesn't indicate what.
Sorry, 1 second. Let me look. My apologies, Your Honor. I do have a brain injury, so if you would just give me
No, that's
an
quite
extra
all right.
additional few seconds to sort through all
Quite all
these
right.
documents here. Thank you. Okay, so I have a certificate of service that I served upon Trooper Ryan Hawk, and I served it at the State Patrol number 337 District 5, and it was other, but I had given it to the, and I have it filed as well.
I know, I'm
I
looking
had
at
given
it right
to the-
now. My concern is that I don't know who, usually when you serve it, if you don't serve it upon the actual trooper themselves, it would indicate like who you gave it to.
I gave it to an officer that was behind the desk, and I was told that they were going to serve on my behalf. Or I don't know if it was an officer or a clerk.
So I do see, and I see that you filed these things. I'm not trying to hold you up in any particular way. I want to make sure that we have everything. I want to make sure that the service is proper. My inclination right now is my concern is that the proof of service that's filed is not quite clear as to who it was served upon. If it was not served directly upon him, I need some kind of information. And you did the personal service yourself?
Yes, so I personally went to the Washington State Patrol to the correct district. It was his district. And I believe that I was following all the rules and procedures. They would not let me direct access to him. Otherwise, I would have served him personally, or if I had a way to get to him personally. And so,
generally, you're
as
not
far as
supposed to
I
be
was-
the one serving them yourselves if it's personal service.
Well, that's why I did not serve it myself. I actually gave it to the clerk that was there.
So then it's substitute service is what that's called. So if it's substitute service, there needs to be some indication upon who it was served upon. I understand that it was served upon the office.
Okay.
But this is what I'm going to do. I'm going to try to set this over to a date that's on my calendar. Let's see. Are you available July 14th at the same time, 9 o'clock?
Yes, would that be in person?
No, it would still be on Zoom, but what I want you to do is file a valid proof of service upon the officer, or the trooper, excuse me. If you wish to, so it's not the issue is not the subpoena itself, it's the proof of service that needs to be filed. So I can't find that there was valid proof of service for him to be subpoenaed here today.
Okay.
I'm giving you a chance to correct that.
Okay. I am willing to do that, and to do that a valid proof of service. But I am requesting an in-person hearing because I do believe that is violating my religious rights and our religious freedoms.
All right, that has been noted, and your objection stands. The denial will still also stand, and we will continue this as a Zoom court hearing.
Ma'am, respectfully, I am Amish, so currently what we are doing is violating my religious conscience, and I believe that it is violating my right as an American. I'm not trying to delay the process. I'm just trying to, I just object to another Zoom hearing. I'm appearing under protest that the court has compelled this format. I do not consent to Zoom. I do not waive my religious objection. The court has been placed on notice that Zoom violates my sincerely held religious beliefs. Forcing me to proceed by Zoom places a burden on my religious conscience and denies me meaningful access to the court unless I violate my faith. I move for immediate dismissal. The court has ignored or failed to rule on my religious accommodations request and my pending motions, yet is it attempting to proceed anyway that violates my religious rights, due process, and my right to a fair hearing. Before
Okay.
anything happens, I request that the court state on the record why you are denying my religious objection and explain the legal basis for forcing me to proceed by Zoom despite my objection.
Mr. Sturgeon, the previous court has already ruled upon your motions. You had indicated that they have not ruled on any motions, whereas the court I just read off to you at the start of this hearing, the court's rulings on 3 separate motions that you had made. Court had previously denied your request, and it's going to continue to deny your request. Your objection is noted. Okay, and we're going to proceed to
Okay.
the July 14th. We're going to set this over to July 14th at 9 o'clock. It will be in Zoom. And then if you
Your
want
Honor.
to file that valid proof of service with the court, or if you do file that and the trooper still doesn't show, we can proceed then.
Your Honor,
Yes.
I have another objection. I was not driving a 2006 Ford Crown Victoria, so I object to that.
Okay, we can do that at the contested hearing that you stated that you've subpoenaed the officer. If you subpoenaed the officer, that kind of puts it in a different category, and we need to make sure that we have valid proof of service filed. I'm giving you a chance to fix that.
Okay.
Okay? All right, we'll see you back here on the 14th. Thank you.
All right. Squally, your name, please.
Me?
Yes,
Michael Weeks. Michael Weeks.
thank you.
You're welcome. Thank you, Your Honor.
And I think we spoke last week, Mr. Weeks.
2 weeks ago, I think.
Okay. Yeah, your memory's better than mine.
That's okay. Thank you. 17 days ago, actually.
To be precise. Okay. To be precise, actually, it wasn't me. It was Commissioner Stillwell that you had back on the
I did
27th of May.
talk to you that same day, but I come before you on that same day. So I did talk to you.
Okay. All right. Chris, good afternoon.
Good afternoon, Your Honor.
So to sort of summarize your violation report of May 1, it looks like failure to report to probation and then numerous subsequent charges. Is that essentially correct?
Yes, Your Honor. Yeah, Mr. Weeks has a lengthy warrant history. Probation has counted a total of 5 warrants being requested for Mr. Weeks since he's been assigned to active probation since February.
All right. And Mr. Rusnak?
We are stipulating to the failure to report to probation. Talking with Mr. Weeks and looking at the dockets and the other cases, I believe he got PR'd on those cases. They're trespassing cases, all 3 of them. But notwithstanding that, they are pending new law violations that haven't reached disposition. I'm asking the court, I don't want to be presumptuous because there are a new law violation is a more significant non-compliance event. But notwithstanding that, he's been in for a while. I did talk to him. He says he'll come back to court as directed, and I didn't really specifically touch on probation, but he'll touch base with probation as well. I'm making that assumption that you're okay with that too, Mr. Weeks. We didn't talk about that aspect.
Yes, I'm definitely going to make it probation.
Okay. And I think the most far out in time temporally on these new cases is something like August the 19th or something like that on the trespassing cases. Maybe see how he's doing with probation, reserve on any findings and sanctions, because I'd rather, instead of sanctioning him on not going to probation and then having him come back and get sanctioned yet again in piecemeal, if he has to end up taking a plea or he's found guilty at trial on one of these new cases, I'd just say reserve findings and maybe do everything in total and in toto and reserve sanctions as well and see how he does after these cases shake out. Obviously, if he decides he's not going to go to probation for whatever reason, we can summons him back in before those cases reach disposition. But Hope springs eternal that he's interested. He's going to go to probation in the interim.
All right, Mr. Weeks, you've said a lot, saying how, you've tried and it's nobody told you and all that stuff. So number one, I've told you, you have to go every time Chris wants you. There is no schedule unless he tells you he needs to see you, then that's when you need to be there. I don't want you making up a schedule. Number two, I'm going to release you on these two, and I'm going to see if you can live up to your words. You have to report to probation by noon tomorrow. If you don't do it, no, you can unmute him. Or get the jail to unmute you. I guess we can unmute you from here. Okay, all right. Did you hear what I said?
Me? Yeah. Yes, I did.
By noon tomorrow. And if they're not there, if they're out on their lunch break, I want you sitting there until they get back from lunch. But you have to be to probation by noon tomorrow. No excuses. I don't want to hear about I didn't have transportation. I didn't know. I don't want to hear any of that stuff.
Okay. That's
So
fine.
right now, based on what I see in the documents, I can't trust you. So I'm going to put you really on notice. You have to show up. You've got to prove that we can trust you. Otherwise, I'm going to order a warrant for you, and we'll just keep you in jail until these cases resolved. And it looks like you're up and through the second week of July before you conclude all those Tumwater cases. So you'll be sitting in jail that whole time.
I will make it for sure.
If you can't be a probation. All right.
Bridge Drive.
By noon tomorrow.
Is that the courthouse?
It's at the courthouse up here on Courthouse Hill in Thurston County. You know where it is.
In Olympia? Okay.
Yes, not downtown Olympia.
Okay.
It's up at the courthouse. You know where it is, and you can take a bus up here.
Okay.
All right, Chris, we got it. And if he's not there by noon, come let me know, Chris, and I'll issue warrants.
Understand, Your Honor. Thank you.
And
All
Your
right.
Honor, I'm assuming you're not modifying the no contact order?
I haven't even heard from Ms. Weeks yet, so we're going to address, first I had to get the hearings off the table. Okay, Ms. Weeks, come on up. Did you have something you wanted to say?
Well, yeah,
Yeah, okay, wait till you get up here where there's a microphone so they can hear you.
I'm here to hopefully drop the order and save everybody's time. I've been in the hospital several times and I've had 3 strokes and things don't look well. So it's going to keep happening. My strokes are. So I just want to clear the slate and get this over with because I don't want no ties. I don't want to pass that way. That makes any sense, it's gonna keep happening, his making type of thing. But I just want to get the order over with. I don't need it. I don't want to waste any more time from anybody,
Okay, so I hear you say that you don't want the protection order,
Yeah.
and it was entered after Mr. Weeks assaulted you, an assault that he was
It's
convicted
been a
for.
long time ago. It's just, I'm done with it. I just don't want to deal with it anymore. And I don't want to see him struggling through all these problems and creating these problems that are happening and reoccurring over and over. I want to go out. I want to go out clean, no ties. No ties. That's
All right, I understand what you're saying. And Ms. Vitale, did you want to add anything other than what you told me before?
No, Your Honor, I'll just stand by my previous statements.
Okay, looks like this order was entered back in October of 2025.
okay.
And the only criminal charge related to Ms. Weeks is the protection order violation charge, which occurred right after the order was entered. The subsequent charges aren't related to directly related to Ms. Weeks. Based on Ms. Weeks' request, I'll sign the rescission. So I'm going to relieve you of the no contact order. That's on Make sure it's on that case.
That makes everybody's day better now, doesn't it? Thank you for waiting.
Okay, so
Thank
sit
you.
tight. We're going to give you a copy of this so you have it with you.
Oh, okay.
All right, I've rescinded no contact order with Ms. Weeks and Mr. Weeks by noon tomorrow, otherwise warrants are ordered.
Okay.
And Ms. Weeks, hold on a second, we'll get you a copy. Okay, Mr. Weeks, you can let them know you're done. And Victor LaGuardia,
Sure.
do you say Guardia or Guardia?
LaGuardia.
LaGuardia, okay, just like the airport.
Yes, sir.
All right, and it's Victor Brandon LaGuardia?
Yes.
All right. And Mr. LaGuardia, did you have a chance to go over your constitutional rights with Ms. Dutch?
Yes, sir.
Any questions for me about those rights?
No, sir.
Thank you. And Ms. Dutch, any objection to probable cause on the violation protection order charge?
No, Your Honor, we can stipulate for purposes of today's hearing, waive any further arraignment, enter a plea of not guilty, and request a court-appointed attorney. Mr. LaGuardia does receive public assistance, and he has Attorney Hofstad on his post-conviction matter.
All right, thank you. Well, no probable cause on a charge of violating domestic violence protection order, enter a not guilty plea for Mr. LaGuardia to that charge. And what's your work status, Mr. LaGuardia?
Not working at the moment.
And tell me why.
I'm getting enrolled in school.
You're in school?
I'm getting enrolled in school.
Okay. When was the last time you worked?
It's been a while.
Okay. And is there any medical reason you don't work or you just haven't worked? Say that again.
Mental health.
Okay. All right. I will appoint counsel to represent you. I suspect it will be Mr. Hofstad since he currently represents you on the other matter. I don't think he withdrew. Nope, I don't see any indication of that. Even post plea. So Mr. Hofstad remains as your attorney. And the probationary allegation on that case is this new law violation alleged. And city's position on release.
Your Honor, Mr. LaGuardia just pled out to the same charge with the same victim from the same no contact order about a month ago, May 5th, where he received 30 days jail. And now we are back for another violation of a no contact order where probable cause was just found. The defendant has a dismissed assault from June of last year with the same alleged victim. As you can see, there are current open felony cases. He has violent history, older, but still there. Several assault charges, unlawful possession of a firearm, etc. Given that he basically a month ago, I believe, pled out to the same charge, and he is still violating that no contact order, the city is requesting bail in the amount of $10,000. We are requesting a condition to abide by all previously imposed court orders, no new criminal law violations, and return to all scheduled court dates.
All right, thank you. Ms. Dutch.
I will note from my review of the probable cause statement that no actual contact was alleged. Mr. LaGuardia does have some hearings pending in Thurston County that he would need to be out of custody for. He provided good contact information. I've forwarded that to the court. So given the totality of those circumstances and the presumption of release, we would be asking for an out of custody pretrial hearing.
Thank you. And Ms. James is the alleged victim of the violations, Ms. Vitale. And Mr. LaGuardia, based on the history pointed out here, which is the very quick turnaround for another alleged violation protection order, when you disobey an order of a court, then the court doesn't feel like it has a whole lot of possibilities in doing alternative resolutions here. If a court orders something and then you immediately turn around and violate it, it's like, well, the only thing we can do is keep you locked up. And then I'd also note the lengthy history of assaultive behavior that's resulted in convictions. For those reasons, I'll hold you in $5,000 cash or bond on each of the two cases, total of $10,000 cash or bond. And we'll set a new court date for you. And what day is Mr. Osted's day?
Tuesdays, Your Honor.
Tuesdays, thank you. So we'll make that 30 June. And Mr. LaGuardia, you going to be able to post bail or not post bail?
No.
Okay, I'll put that at 1:30 then, June 30th at 1:30. All right, on the new case, you're to obey the no contact order that says you're not to have any contact at all with Ms. James. You're not to possess any firearm or other dangerous weapon, have no criminal law violations, and I want you to clearing that pandemic warrant you have out of Kent when you get the opportunity. All right, thank you.
That concludes my matters, Your Honor.
Thank you, Ms. Stewart. Or pardon me, Ms. Stewart, Ms. Dutch. Thank you, Ms. Dutch.
Thank you.
Yep.
And in the meantime, we'll turn to there at, let's see, the Nisqually booth. Ma'am, the booth titled Nisqually / Lacey. Your name?
Kira Dickman.
You said that Kira Dickman?
Kira Holm Dickman, yes.
Okay, all right, thank you, ma'am. All right, looks like, Ms. Dickman, we're here for a competency hearing. All right, and I've had a chance to review that competency evaluation report. I'm going to hear from the attorneys on their position. I'll go ahead and start with, okay, looks like we've got Lacey and Olympia. Okay. All right, well, let's see. We'll start with who's from City of Lacey. Is that going to be you, Ms. Ruiz?
Yes, Your Honor.
All right, and so let me just get my bearing straight on, okay, so this is matter 5183, the City of Lacey matters. We'll get Ms. Ruiz. All right, anything further from you, Ms. Ruiz, as far as the competency report?
No objections to the competency report, Your Honor. I did speak with Ms. Gorisco, her main attorney, and she instructed me to defer to Olympia's counsel, so I would request to defer to them on how to proceed. Thank you.
All right, thank you. And Ms. Eddy, are you on for the City of Lacey?
Yes, good afternoon, Your Honor.
All right.
So I guess Lacey's position is that the court should issue the finding as to incompetency at this time for the defendant, and it's the city's position that this is a serious offense since she's still pre-trial, and that the court should order restoration.
All right, thank you. And I think just for ease of getting through the hearing with the two jurisdictions, I'm going to take notes before setting hearing. So Ms. Deckman, what that means for you. So the Lacey case, that's a charge of driving under the influence, which is defined under the competency restoration statute as a misdemeanor, serious offense that is eligible by statute for restoration. What that means, ma'am, is no later than 7 days from today, there would be a hearing on whether to issue restoration for competency. So the City of Lacey is requesting that hearing. I'm going to hear now from the City of Olympia that has the two other matters here, matter ending in 4962 and 6427. With that, looks like we've got Mr. Nguyen. Good afternoon. For defense.
Good afternoon, Your Honor.
And Mr. Nguyen, position from defense on the competency here issue?
Your Honor, I also read the competency evaluation, Your Honor. Just my thoughts. I think this was said a couple of days ago. I think Judge Buckley might have indicated that he couldn't make a finding because he might think that Ms. Dickman is competent, Your Honor. So there wasn't a finding until today. My dealing with Ms. Dickman in the past is it's in line with what the evaluation is indicating, Your Honor. So I guess that being said, I don't have any exception. I don't take any exceptions to the competency evaluation, Your Honor.
Okay. All right. Thank you. And with respect to the city of Olympia, Mr. Carver, I know you've already filed a motion objecting to dismissal and asking for restoration under both cause numbers. I've got those motions in front of me. Anything to add?
No, just a clarification. I think that the 1077 from that was requested from Buckley, I don't think that. I think it was just amended to be an in custody review. I don't think that there was a determination by Judge Buckley as to whether the competency evaluation was sufficient or not.
Okay. All right. And then just for clarification as well, matter ending in 4962, that's discharging firearm in disorderly conduct. That case has, I believe, eligible by statute for restoration charge, at least with discharging firearm in 6427. I don't believe those charges are eligible necessarily specifically by statute, but there is the argument for restoration of it for those non-serious offenses under RCW 1077-6653.
So,
and again,
Your Honor, the city's argument is that it falls under both categories. The crimes included under harassment as a serious offense, that's 9A46060, include reckless endangerment.
Okay, either way. All right. So, Ms. Deckman, what this means for you is, and I agree, so I've read the competency evaluation, and I'll make the finding of not competent to proceed in all three of these cases. And what we're going to do next is under the competency statute, you're entitled to a hearing on whether restoration is appropriate in your case. The City of Olympia, I believe, is part of that motion. Has already laid out its argument for why restoration is appropriate in your case. So what we're going to do, ma'am, is have that hearing a week from today. So that will be June 18th at 1:30.
And I apologize, Your Honor. Before we, is this a hearing for restoration or a return on the restoration? Or I'm sorry, I'm unclear as to the hearing a week from today.
So a week from today is whether restoration is appropriate, unless one of the, if either of the defense attorneys, if you want the hearing, or if you're kind of stipulating to restoration, that's
we're stipulating to restoration. I think that's what the evaluation was recommending also, Your Honor.
That's correct. Yeah.
So
Ms. Ruiz?
Yes, Your Honor. For Lacey, we will also stipulate to restoration.
All right. So with that, thank you both for clarifying that. That does help. All right. So what that means, Ms. Deckman, is there's part of that competency evaluation did recommend restoration. And so rather than keep this on hold for another week to have a hearing, what we'll do is order that restoration.
May I ask what that means?
Yes. So what that means is that, well, primarily there's medication that's available that the person who, and so there's medication that would be available for you to take for that purpose. And this is to allow time for that to happen. Does that make sense?
Yes, I do have some responsibilities I need to take care of and appointments I need to go to specifically with my hen provider for my rent to be paid. Would I be able to do that in outpatient?
All right. Well, let's see.
Because I do disagree with the designation of incompetent. However, I understand I need to follow what the court says. And I'm just wondering if I would be able to go in so I can take care of things such as meeting with my hen provider, making sure my rent is paid, making sure I don't lose my apartment, things of that nature, and then do outpatient treatment for that, which I'm more than willing to do for either mental health or I believe the other one was substance use. Either one I can do outpatient.
All right. Thank you, ma'am.
And I just wanted to point out I have no record before these charges as of 2024. I have never been arrested. I've never been in trouble in my life, except for 99 when I was a child.
All right. Thank you, Ms. Deckman. I do appreciate those comments. Let me take a look at a recommendation on the nature of restoration, whether in inpatient or outpatient was part of the recommendation as well. I'm going to refer back to that section here for a moment. So give me a moment while I review this. So I think on that, so the recommendation, but I'll hear from the parties. The evaluation does recommend, or at least it indicates that Ms. Deckman would benefit from inpatient services. But I think I'll hear from the parties on that as well. I think I likely understand the defense position on inpatient or outpatient. So I'll hear from the prosecution. Ms. Eddy, I'll start with you with City of Lacey. Do you have an opinion on that?
Yes, Your Honor. The city would ask for inpatient restoration. I believe one of the issues when one of the factors for the court to look at for outpatient restoration is the defendant's willingness and history of taking medications as prescribed. I do believe when I noted in this evaluation, it did talk about how the defendant on page 4, it indicates on the medication treatment adherence section, the defendant is currently prescribed, and I apologize, I don't know how to pronounce it, Abilify, an antipsychotic medication, and she's not adherent to her medication. And I believe I saw a couple other references to that, again, that not taking the medication for that diagnosis. So that's the city's position.
All right, thank you. Mr. Carver?
I agree with the City of Lacey's assessment. In addition, I would just point out to the court the numerous new charges and failures to appear that have occurred during the past couple years with Steigman. There being escalating incidents of serious offenses that have occurred.
Okay, thank you. And I see your hand up, ma'am. I'm going to hear from the defense attorneys as well, give them a chance to weigh in. I'll start with you, Ms. Ruiz.
Yes, Your Honor, we would request that you consider outpatient services. There's no definitive recommendation by the evaluator that it would be necessary to do inpatient treatment. She does note that there was previous outpatient treatment, and Ms. Stickman has relayed to the court today that she's more than willing to participate in these programs in an outpatient program. I would also just note her potential for more instability in having a potential housing crisis if she were not able to participate in outpatient programs. So we'd request that the court take that into consideration and her willingness.
All right, thanks, Ms. Ruiz. All right, and finally, Mr. Nguyen.
I would agree with Ms. Ruiz, Your Honor. I think she said it best, Your Honor. looking at Miss Deckman's how long she's been in for. She's been in for almost 15 days, I believe, Your Honor. She's indicates she's willing to go to Western State to do the restoration. And if she doesn't, she knows where she will end up again. And this time, most likely, or the next time, it will be an inpatient process.
All right, thank you. All right, Ms. Deckman, I've heard from a lot of folks, and I've heard from you as well. You've certainly raised some compelling reasons for outpatient. I'll give you a few more moments if there's anything further that you'd like to say.
I have not been actively prescribed Abilify since last year. That chart is a year old. I went off of it with my doctor's permission. I went off of Abilify with my doctor's permission. I was on 20 milligrams a day as an antipsychotic. I had been on it and on and off and on and off for a few years, but I have a history, if you go back 20 years, where I was diagnosed with bipolar disorder. It was a misdiagnosis years ago. And I tried for 20 years to take every medication they prescribed for me. You can go to Heritage Family Medicine, Dr. Richard Fiola. That was my doctor for 20 years, and Betsy Foreman Serdar. And she was later at Northwest Resources. They took care of my medication management for 20 plus years. I took every medication they tried to prescribe for me, whether they worked or not. I kept trying. And I have absolutely no problem taking medication when it is prescribed to me. Abilify, I went off of last summer, with my doctor's permission. I have not been prescribed anything since then. So my refusal to take medication since I've been in jail is a refusal to take a medication that I was not able to dose up on, where it can be very dangerous to take something like Abilify if you do not dose up. You can get seizures, you can die. That's what I was unwilling to do, was take a medication I had not talked to a provider about and been prescribed again. I'm very willing to take any medication that is prescribed to me after I see a provider.
Your Honor, I'm just reviewing the court file, and I don't see a recommendation of from or an evaluation by the outpatient services either.
I just want to say I do want to comply with what the court requests of me. That's my number one priority.
All right, thank you, ma'am. All right. So, Ms. Deckman, I understand what you're telling me, and I am taking that all into consideration. I am going to order it to be inpatient. The reason being is you're at least on matter, the Olympia matter 4962 at least. Looks like the judicial officer made the decision to hold you without the opportunity to post bail after a $5,000 no walk bench warrant was issued for failure to appear at prior hearings. And so under the statute, for as far as factors to look for and whether it's inpatient or outpatient, I do find that that at this point, I find that the report for outpatient competency restoration is inappropriate.
I apologize. My mail had been being stolen and I forgot about the court date. And it's not an excuse, but it was not anything where I was trying to avoid the courts whatsoever.
No, I understand, ma'am, but at this point though, I am going to order that inpatient restoration. That what we'll do is we'll set a court date. They have up to 29 days for restoration. We're not going to go beyond that. And so I'm going to set a hearing. We're going to go to Friday, July 10th.
I understand this because I'm 1 year away from a chemistry degree. I'm not incompetent whatsoever. And that is not at all what the woman, when I was on the meeting with her, that's not at all even the impression she gave me when I got off of the call. I never spoke with a forensic navigator. I mean, I feel like I'm being railroaded. I'm not incompetent. I understand very much the consequences.
Your Honor, is Your Honor setting July 10th?
Yes, July 10th for the competency hearing. Under the statute, the inpatient competency restoration can be up to 29 days. And so if that's completed earlier, then she can be put back on the calendar. But that's under the statute, that's the amount of time for restoration.
May I request?
And Your Honor, does that include the time that she's in custody before they come to transport her?
That I don't know. The statute talks about I think this is one of the performance targets. Well, let's see. No, it may not exceed. So it shall not exceed 29 days. Yeah, it doesn't say. It says placement under subsection 2, which in this case is inpatient restoration shall not exceed 29 days if the defendant is ordered to receive inpatient competency restoration. Yeah, so that it's unclear to me if the parties want to provide more information, but I'm gonna err on the side of not keeping her longer than that and setting a hearing on Friday, July 10th, and that will be at 1:30. All right. Thank you, Ms. Deckman.
Thank you, Your Honor.
You're free to be taken back, ma'am.
Mint Vu versus Thurston County Collision and Summit Towing, number 39479. Okay, and then you folks come up to the table too. It's easier for everybody to hear you if you do. All right, and Jeff LaCroix, you're here representing Thurston County Collision.
Yes.
Right. I'm going to address a preliminary matter in this case before we launch into it. And it may partially resolve the case. Just a second here. There we go. Okay, so there are two defendants in this case, Thurston County Collision, and it appears that the claim there is based on an agreement to do some repair work on a vehicle. Second defendant is Summit Towing, and the claim there appears to be based on Summit Towing impounding the plaintiff's vehicle at the request of Thurston County Collision, subsequently selling, auctioning that vehicle. That second part is what I want to address. Okay. And this is going to be a question to you, Ms. Vu. Ordinarily, when a vehicle is impounded at the request of a private party, the impounding authority provides notice, and then that triggers a timeline for an opportunity to challenge the impound. There's court procedure for that. And as part of the hearing in a case like that, you can recover costs, including the cost of the impound, the cost of storage, and also any damage that may have occurred to the vehicle or any loss of use of the vehicle. Those are all part of a cause of action in an impound hearing. And that's an exclusive remedy in the situation where a vehicle is impounded by a private party. In this case, reviewing the record, it doesn't appear that any such request was made within the statutorily allowed 10 days following the notice of the impound. So in my view, and I'll hear your position on this in case you have a different view, but it appears that the failure to request an impound hearing based on the claimed actions of Summit Towing The failure to do that within the statutorily allowed 10 days precludes you bringing this claim in small claims against Summit Towing. So do you have any response as to why the ordinary impound hearing process was not used and not appropriate in that case?
So yes, Your Honor. So I had foot surgery during that time frame and recovery. So I didn't even go to my mailbox for like a month. And the most important thing is I was not expecting this at all because of the constant communication that was happening between me and TCC, the repair shop. We were communicating regularly, and just a sudden towing and auctioning off my car was so unexpected that I didn't think I had to go to the mailboxes to see what was going on, because we were doing all the communication via texting. So when I did open the mailbox, it was already past I guess they sent me like two notice, the first notice and then a second notice. And they may have met all the timelines, but that is the reason why I didn't get any of the notices until it was after it was auctioned off. Now, the reason I named them as a defendant is when I went back to the office after I found out that it was auctioned off, I immediately went to the office, Summit Towing's office, and talked to Brooklyn. I suppose she's the manager or receptionist there, and she was the one that was mostly communicating with me. And I told her my situation and how that was an improper tow and impound and final auctioning off. And she said that it was abandonment because I said that I was in constant communication with TCC, so it's not abandonment at all. And she said, yes, she was aware. They were aware that we were in communication, but still, I did not pick up my car. So I don't know how they could have towed a car knowing that it wasn't an abandonment issue, which is just leaving a car there, not having heard from anybody. That would be abandonment. And also, I noticed in their exhibits they had some photos of their Summit Towing signs near the office, but I also have an exhibit Z to show that they didn't have a sign at the entrance. And I think the law says that they have to have signs at every entrance, and every visible part of like outside the building, inside the building. I felt like they knew what was going on and they just decided to take the action because they were sort of on the side of the defendant one, and then the pure refusal to just provide me photos.
Ms. Vu, I'm going to stop you there. Okay. These are the kind of challenges that can be raised in an impound hearing. And I don't think it's proper to revive a cause of action that's passed by bringing it in small claims. In other words, you can't extend the time allowed to challenge an impound by bringing it as a small claim instead of challenging the impound appropriately in the first place. My intent is to dismiss some towing from this case. So any part of this action that claims damages for Summit Towing impounding the vehicle and subsequently auctioning it after having impounded the vehicle at the request of defendant Thurston County Collision is going to be precluded. That the time for that cause of action passed. All right, so I'm going to go ahead and explain to you how we'll do this and get you sworn in, and I'll hear your claim and your defense. Okay. So what I'll do is I'll swear the parties in. The plaintiff will then go first and present their claim. Ms. Vu, you're the plaintiff in this case, so you'll present your case first. That means you'll testify about your claim and refer the court to any exhibits that have been properly filed in the court file. And then if you have any witnesses who you would like the court to hear from, I can swear them in and hear from them. After the plaintiff's had an opportunity to present their case, it'll be the defendant's turn. Same process. Mr. LaCroix, you'll tell me about your defense to the claim. Through your testimony, refer the court to any exhibits that have been properly filed. And then if you have any witnesses who you feel that I need to hear from, I will swear them in and hear from them. I'll hear from each party once. We won't go back and forth. I'm going to ask you to keep in mind a couple of things. When the other party is presenting their case, I'll ask you not to try and stop or interrupt them, even if you believe that they're telling me things that are inaccurate or not true. Please keep in mind that you will either get a chance in a few minutes to tell me your side of the story, or you've already told me your side of the story and I'm aware of it. I may need to ask you questions from time to time, and I'll do that in order to make sure I understand the nature of your claim or the nature of your defense. I may also ask questions or interrupt you from time to time to keep things focused on just the facts and circumstances that'll help me resolve this case, and not on things that are kind of tangential and don't really contribute toward getting a resolution to your case. All right. Now, I have dismissed Summit Towing as a defendant in this action, and unless you're going to testify as part of the defense, then you're free to go.
Thank you so much. You're gonna watch?
It's up to you. Yeah, totally free to do that.
I'm gonna go back to the office.
All right, I'll get the both of you sworn in then. So can I have you each raise your right hand? And do you each swear the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right, Ms. Vu, you're the plaintiff. You can go right ahead.
So on August 18, 2025, I got in a car accident on the freeway, and one of the wheels got hit, and just the corner of that left side, the front left side, and my car became disabled. So before I towed it to a shop, I called around to see. I called up quite a few shops to see if they would use used parts to fix my car, because obviously it's, my car is like about 10 years old, and I just didn't. It would make no sense to have put in new parts. So I called around, and then I got to Thurston County Collision. Ellen McGill was the one whom I've been dealing with all this time. She was the manager, and she said, yeah, they use used parts. That's what they were going to do. And so just with that information alone, I decided to tow my car to have it towed to Thurston County Collision. And from here on, I'm going to say TCC just to give brief. So it was towed on August 18th by Black Lake. Well, anyways, Black Lake Towing. And when the car got towed, the office was closed and there was nobody there. And so we really didn't know what to do. I mean, I didn't know what to do, but the car was towed there. We were just like a couple minutes after 5. And the towing company demanded payment at a different rate. It was the different rate than what was told to me on the phone. And you can also see from their invoice that they canceled out a rate and they put another rate. And then he told me that on top of that, he wasn't happy about it because the driver wanted a higher rate and he didn't agree with what the office person said. But then I was willing to pay that. But then he said, well, I'm going to have to charge you extra for paying a credit card. And I didn't have cash. So in the end, I ended up not paying for it. And I said I was going to call their office, which I did the very same day. Nobody answered the phone. The next morning, nobody answered the phone. I told them, look, I have a situation here. How much do I owe? This was the rate that I understood it to be when I called you guys. Anyways, so that was that piece of it. And then, so on the 19th, I sent an email to TCC for an estimate. I said, I've dropped off my car. I just want to get an estimate. And then immediately after, I got an estimate on the 19th, very quickly. But then the estimate really didn't show any, it was all OEM, aftermarket OEM parts, new parts. It didn't indicate at all that they were going to use used parts. And this is where in my suit, I found out that there's kind of deceptive, and it may be kind of a a trade issue here, but I'm not going to focus on that in this suit. So anyway, so I asked about that in email, which is in in an exhibit 3A. 3A says, I drop off your car and I'm interested in using used parts only. And then I would be there on August 20th to take photos on my car. And on the 19th, and then yeah, exhibit 3B continues to say that I wanted that I was surprised that they weren't going to use used parts. And just by the rate at which the estimate came back, like almost immediately, gave me confirmed that they actually didn't really make an effort to go look for the used parts. And I really was expecting them to take some time. And then exhibit 3B will show that no, they don't have, they're saying that used parts are more expensive than new parts, which made no sense to me. But basically I told my car there, and then I'm being told, no, we're gonna have to use new parts. So this is why it took me a little while to kind of decide what I was going to do, because it was not what I expected. And then, so when I showed up, and I asked all these questions in email as well, and it's in the exhibit. So on the 20th, I showed up to take photos of my car. And by that, when I got there, well, actually exhibit 1A, you can see that was the condition of my car when I dropped it off. It was just the front. It was the front wheel and just the front left corner of it that was damaged. And then I showed exhibit 1B. The interior of the car was perfect. There was nothing, I didn't see any damage at all. It was all like exterior stuff to be fixed. So on the 20th August, I went to, in the afternoon, I went to take photos of my car, and I realized that I saw that it was already kind of dismantled. I thought they were going to wait for me, instructions on how I want this done, make agreements on what's going to happen, but they had already disassembled the fender and a bunch of other things that I didn't know what happened, because it just looked like a different car. And well, so I have pictures of that too, which, let me see where they are, but it's some, okay, so Your Honor, what I'm going to do is I'm going to give you kind of a brief overview, and then I'm going to go through the exhibits to kind of capture any gaps there, if there were any gaps. Is that approach okay by you? Instead of going back and forth between the exhibits and my accounting of what happened.
Yeah, I mean, you can, yeah, present your case, yeah, however you'd like.
However.
If I
All
find
right.
it confusing, I'll let you know.
You find it confusing?
No, if I do, I'll let you know.
Oh,
Otherwise,
okay.
just go ahead.
Okay, sorry. So anyway, so yeah, it was already dismantled, and it has already gone through a I don't know if they call it at that time. So, you know, there were times when they say it was a tear down, and at times they would say it was not a tear down. I had no idea, but I knew that tear down sounds like a really serious thing. But it looked like the whole fender was out, and I don't know, and there were some parts that had been pulled out, perhaps to see what was behind those parts. But that was all done before they had a conversation with me. And then they had me sign it looked like a general repair authorization, which is exhibit 4. So my understanding of this repair authorization is it was written in very general, high level language. It's just that I'm allowing them to inspect the car. I was not expecting them to do tear down or any kind of major damage to the car where they couldn't put any parts back. Because at that point, I wasn't sure if I was they were going to be the repair shop. I just wanted to get an estimate. But when I got there on the 20th, I saw things disassembled. I was starting to wonder how I was gonna, if I didn't go with them, how I was gonna tow this car to some other place, because there were parts flying all over the place. So they had me sign this on the 20th, this repair authorization, and I read it, and it said the storage fee would only be incurred if the car was not repairable, or if it was repaired and I didn't pick it up, which I knew in none of those situations would ever happen. If I had it repaired, why wouldn't I pick it up? Why would I leave it there? I want to drive it. And then I knew it was repairable because I just got an estimate. I got the estimate from them on the 19th saying that it was repairable at about $6,000. So I signed it. And so what happened was then this authorization shows that it was dated on the 18th, but really I signed it on the 20th. And you can see that it's a different handwriting. It was backdated, and I didn't notice it then. And or maybe I did. I don't know if I noticed that, but I didn't think it mattered until now. In retrospect, I'm thinking that they actually did the disassembly and initial teardown is what I call it, even before I signed the authorization. So when I got there, Ellen asked me if it was okay for them. They've done some work, some tear down work already, but if it was okay for her to like lift up the car and look underneath because they couldn't see possibly some of the damages. So at that point, I realized the $6,000 wasn't really the full amount. It could be more. And so I said it was okay for you to lift up the car. It would be of no damage to the car, but I was very specific that I don't want any damage to the car, or that it was going to be a big major thing where I was going to be charged for it. And I don't see any tear down charges being mentioned in this general authorization either. So I said, okay, that's what I said. Okay, if you're not going to charge me for it, I don't see it, why you couldn't look under the car. So, and she said, no, you're not going to be charged for that until we you approve the estimate and we move forward with it. And so that's the understanding. And it's the general understanding of what happens when you take a shop to a mechanic is they don't charge you to get the estimate is free. And you don't actually get charged for repairs until it happens, or they don't do any tear down work or whatever until it's all approved and discussed. So I left the car there, and I actually hadn't heard from them in a while. And but I did get I know Alan did say that there might be more charges following that, but it was never like solid or final, just that there could be more depending on whether the arms control is this. So to me, it was like, this is really confusing and scary. I don't know what I'm going to do. I want to fix my car, but everything was just so out there and like not tied up that I was afraid what the final cost was going to be. And in this general authorization, it did not say, I think the RCW says that that they can't charge more than 10% of the final estimate. It doesn't even say that. And I didn't know. So in my mind, I thought, hey, this final bill could be anything, right? If it was there, and I would have known, okay, so if the final bill was $10,000, they could only charge me an extra 10% supplement, I would have felt a lot better. And I found out about all these things when, after I was thinking I was going to file a suit. So that was the end of that conversation, so to speak. But then I hadn't heard from them about, I guess, for a while. And then on September, was it? Yeah. One thing is, when I was there, I did notice the Customer's Bill of Rights sign. It was inside the office, but it was behind a door. And then a door was open where you really couldn't see it most of the time. It was not somewhere where it's clearly visible and seen by the customer. And on 21st on August 21st, from August 21st to September 3rd, we were actively engaged in negotiation regarding the repairs. What is this and what is that? What if, and what if I repair this or not? And basically, I was just really disappointed that they were not using used parts after all. So on September 4th, so I had a work issue that I had to leave. So I told them, hey, I am going to be leaving the state. Actually, I was leaving the country. Is it going to be okay if I left my car there? And they said, yes. That was all they said. Yes, you can leave your car there. So, because I was still trying to get information on what else was wrong with my car outside of the $6,000 estimate that I was, so we kept negotiating and asking questions throughout that time. And then so September 5th to September 22nd, we continued to engage in conversation. And during that time, there was no mention of, hey, your car's been here for too long, this is not okay, or whatever it is that they needed to bring up. Because during that time, I was thinking I wasn't going to be incurring any storage costs based on that repair authorization that I signed. It said storage fees would only be incurred if I had repaired my car. So I felt like I was okay. And then before I left, I got an okay from Ellen, the manager, that I could leave my car there. Because the fact of the matter is, my house is only 2 miles from the repair shop. It was not okay. I would have easily towed my car from the repair shop to my house. That would have been no problem at all. There, I had a driveway and a space next to a driveway that could have accommodated my car, but I was really wanting the car.
Ms. Vu, I'm gonna kind of stop you here. All right,
okay.
If we're gonna get through this, we're gonna have to focus on relevant facts here. Okay, this is kind of so far this is just kind of like a narrative of everything, and I'm going to have to focus this if we're going to get down to the sort of legally important facts that are going to get to where we can decide this. So,
okay,
I need to know a couple. Yeah, I need to know a couple of things, and keep in mind you've submitted all this stuff in writing. It's not, you don't have to say it again, so to speak, in order for it to be part of the case. It's the material that you've submitted in writing is part of the record in the case. So, what I would like to know is, first of all, did you pay Thurston County Collision any money?
No, I didn't. They didn't ask for it.
So your claim then is based on the fact that they had your car towed away and you lost your car.
Yes, I lost my car, and I had I looked up the Kelly Blue Book value of my car, which was in I think one of the last few exhibits for $9,300, and I subtracted, according to my research of what insurance companies do with the damaged cars, you deduct 23%. Because the $6,000 included like processes and stuff. So from my research, you would only take off 23% or so on the damage. So I figured my car was worth about $7,000 at the time that they at the time the value of my car. And after the tear down, I did send an estimate request to Capital Collision after they did their tear down. So TCC said that it would take $6,000 to do to repair, at least initially. But then Capital Collision said after what they did to my car that really the damage was $13,000. So what I'm trying to say.
Let me ask you this then. At the time that your car was delivered to Thurston County Collision, after it had been involved in a collision, in your view, at that moment, how much was your car worth?
In my view, my car was worth about, I thought it was worth about $6,000 to $7,000.
Okay.
I mean, I did look up the Blue Book value also, but that was, but it wasn't as specific as the Kelly Blue Book, which is what I then later on found out was actually worth more than that.
Okay. And those Kelly Blue Book values, are they based on a car that's not been involved in a collision?
Yes. Yes.
Okay. So your view,
That's why I took off 23% for the damage, which was what
Okay.
I learned
And
is what insurance is.
How did you come up with deducting 23%? Why is that the amount?
So according to my research, that's what insurance companies do to determine damage. Like if they were to pay out somebody that said they had a car, it was damaged. So that's what they would do is they take out 23%.
Okay.
Or around 23%.
Now, so in your view, that's the appropriate way to value your car. And you're claiming that the reason that Thurston County Collision owes you that value is because they had your car towed away and it's since been auctioned off. And I would like to know succinctly, in your view, why it was wrong for Thurston County Collision to have your car towed away.
It was wrong because we were in communication throughout that time that first of all they wanted me, they had never, there were a few times when I said I'm gonna come and pick up my car. I don't think that I owe you this storage fees, and you guys didn't do any repair. I didn't authorize any repair. I'm glad to come pick it up several times, but every single time I said that, they took my car hostage and said, no, you can't do that unless you paid us the $6,000 for a long time. They said there was $6,000 and they kept adding all kinds of fees. I have an exhibit that shows that there's a admin fee, which was never mentioned anywhere, not even in the repair authorization agreement. And then they added in another exhibit, they added storage, there's admin, and then they added storage admin, and then every time it's a different fee that they kept adding on to it. So so no, I'm sorry, now I lost my train of thought. What was your question again? I'm so sorry.
All right. You said your car was brought into Thurston County Collision in August of 2025.
Yes.
When was it towed away?
It was towed in January. They gave me, it looks like 6.
It was towed away in January 2026?
No, sorry. It was December 16th. And it was just auctioned off in January.
Okay, so December of 2025.
Yes.
Okay. Now, it seems to me, and I'm not an expert, this is just my impression, that looks like your car was there from August to December. So that'd be roughly about 5 months. And that seems like a long time for a car to be left at a collision repair shop unresolved. I mean, that seems unusual to me.
It is unusual, but I want to point out to the fact, if you look at the text messages, is like I want to focus on the fact that I have tried many times to tell them that as soon as I came back from out of the country, I said, even before I came back out of the country, I said I wanted to pick up my car, but they said I owed them $6,000, which I disagree with. And so that was, it wasn't.
What was the reason they offered you that you owed them $6,000 in order to be able to get your car?
They said I owed them first. I either had to repair or I owed them storage.
Because it was sitting there at their lot for those 5 months.
Well, at the time I wanted to pick up my car, it was only 2 months.
Mm-hmm.
So because they held my car hostage and they had a condition to the release of my car, they would not. So I could not pick up my car. And so that was what happened. And at the very end, they gave me a short window period that says, hey, forget about 6,000. Like they keep changing their prices and forget about the 6,000, but I think you owe us the toll money. And then because I told them in one of the exhibits, and I have email for that or text for that that's something I want to deal with directly with that company. It's not a debt that I owe them for, and you like they couldn't just hold on to my car because of something that they were trying to collect for someone else. And aside from that, the amount that they said was owed for the tow was actually different than the amount that was on the invoice. It was a small difference, but it made me just realize I just made me wonder what was going on. And they sent me a copy of the invoice. They didn't send me like any payment evidence or anything, but basically I wanted to deal with them directly with the person that provided me service, and I told them that. So anyways, so all this time I was like in communication with them, and then when they said come pick up your car again, there was not a single communication from them that said you can come pick up your car. It was always conditioned upon some sort of payment or you can't get your car. So it wasn't easy. It was like, you know what I mean? So and it was
Wanted
more like
money from you to release the car.
I'm sorry.
And then they wanted money from you to release the car. And you left the car there.
Yeah, they wanted money that they wanted specifically the $6,000, which I didn't agree with because $6,000 for 2 months is crazy, and I didn't sign. And they kept pointing to the authorization, which clearly said that storage would only be owed if I had it repaired. So I wanted to get my car, but they wouldn't let me have my car was the situation. And then when they told me, finally they said, come pick up your car. I mean, we were in communication, and they could have said, today's the day that we're going to tow your car or impound or whatnot. Because that's the only form of communication we were using was text. And they did not tell me that. And then they filed an abandonment, which the car was not abandoned by any means, any definition of the law. I was in constant communication with them. They did not file a possessory lien. If they felt like I owed them money, wouldn't that be the process they would have taken, and I would have gotten notice of it, and then I would have known that that's what they wanted to do and maybe prevented the auction from happening, but they didn't do that either. So and then all of a sudden my car was towed. And it's unfortunate that I didn't pick up my mail until the very end, or I would have objected to it. Anyway, so
We're gonna have to keep this moving. Now you realize that that Thurston County Collision has filed a counterclaim against you, right?
yes, to which I'm gonna have to question the service of that, because I looked at the declaration and it wasn't clear to me what if they handed it to somebody. They surely didn't hand it to me. I was not even home.
Yeah, I don't know. We'll have to see what they show.
And so there wasn't a whole lot of description about the countersuit except that I owe them $6,000. And anyways, that and so in December, I did tell them that I'm trying to get somebody to tow it, but it was the holidays and it was being really hard to find somebody. I did try and call around, but nobody actually returned my call. I said, hey, just give me a couple weeks in January. I'm for sure gonna come pick it up. They didn't respond to me. And so anyway, they just had it towed for abandonment reasons, and they followed the abandonment procedure, which I feel that procedurally that was wrong too, and they didn't do the possessory lien. If they felt I really owed them money, that's the process they should have gone through, and I would have gotten the proper service notification. So anyway.
All right, I'm going to hear from the defense.
Oh, one more thing.
And
So the repair estimate that I saw that the defendant provided was a different one than they provided to me. The one they provided to me was 3 pages. This one had like a lot of pages, and it showed that there were parts coming from all over the place, but that's not the one I got.
All right. Mr. LaCroix.
Yeah, thank you. Your Honor, Thurston County Collision is a local family-owned business. Our storage space is limited. We don't have capacity to hold vehicles that aren't being worked on. So, a car occupying our lot for months without a repair decision is a real cost to us. With that context, I'd like to walk through the timeline. I'll try to keep it brief and to the point, because the records show that the vehicle sat at our shop for nearly 4 months while the owner repeatedly delayed deciding what to do, never paid anything towards the balance, and did not receive the vehicle even when offered to release it for the tow bill alone. So the timeline, the Mazda was towed to our shop on August 18th. Exhibit 2, the Black Hill towing bill. The owner signed our repair authorization, Exhibit 1. The work order for this job was open on August 19th. From August 19th onward, we communicated actively about the estimate, the parts, and the scope of the repair. That's in Exhibit 5, images 1 through 6. On September 4th, the owner told us she had an urgent need to leave the state, and she would, in her words, most likely fix it, but needed time to think. That's Exhibit 5, image 4. We agreed to give her that time. On September 22nd, she told us she was out of the country and would not be back until mid-October. Exhibit 5, image 6. That was roughly a month with the vehicle sitting in our shop and no decision made. When she re-engaged in late October, about 2 months after the car came in, we explained the outstanding charges. She disputed them. Exhibit 5, images 10 through 17. I point the court to one message in particular. On October 24, she wrote that she would owe the tow charges and could pay them separately. Exhibit 5, image 11. Over these same days, she raised several possibilities: deeding the vehicle to us, having a junkyard take it, selling to us, and then withdrew them, which she was bringing up all these different things, stating October 27th that she had not agreed to deed the car. Exhibit 5, image 18 through 24. And remember, through all of this, no payment was made and the vehicle was not retrieved. After about a month with no resolution, she contacted us again on November 28th. That's Exhibit 5, image 25. And really, to the heart of it, by December 3rd, the car had been with us for over 3 months. We offered to release it if the owner would simply reimburse us for the money that we had out of pocket for the towing bill, $362.01. And we would set aside any other invoices that we had or claims that we had for. If you go back to connect the two things, on October 24th, she said in her own words that she owed the tow charges. And that's Exhibit 5, image 11. On December 3rd, we offered to release for exactly that, the tow charge alone. It was the very resolution she had, that she said she would accept. She did not pay it. She questioned the amount and asked the tow company's name and the bill and the signed bill, which we provided in Exhibit 5, image 28. So from December 3rd to December 16th, the offer stood. The owner had almost 2 weeks to pay the $362 bill, the amount she acknowledged, and take the car. Within that window, she made no payment and did not retrieve the vehicle. That's in Exhibit 5, image 28 through 30. On December 16th, we contacted Summit Towing to remove the vehicle because nothing has been done. And you have the documents for the Summit Towing and impounding process in their exhibits. Even on December 21st, the owner messaged to arrange removal, but now even pushing it out to January timeframe. By that time, it's been Summit Towing has it in their position, so that was essentially the end of our involvement in it. So to summarize, nearly 4 months was at our shop from August 18th. That the entire time the owner paid nothing towards the balance. She left the state in early September, was out of the country until mid-October, and went roughly another month before resurfacing in November 28th. We stayed responsive throughout. And we offered a resolution on October or December 3rd. And she had nearly 2 weeks to pay it and pick up her car. So from that, then it was removed from our lot.
Your Honor, can I say something?
Hey, do you remember what I said at the beginning?
Yeah, I'm asking if it's okay for me to say something.
Is it something you haven't already told me?
Yes, it's
All right.
kind of responding to what he had said to just set the timeline straight.
And we're very transparent in the timeline. It's all there in the text messages.
So what I wanted to say is that during this exactly that the momentum has been slow because my car has been held hostage. And there was not a single time when they said, come pick up your car. That dispute payment should have been something separate, but they have taken a dispute payment and made it into a lien or a vehicle abandonment situation because it looks like they didn't just want to follow the dispute payment situation where, it would be different. I owe you, if they felt that I owed them money, then it would have been send me to collection, but instead they sold my car and called it a vehicle abandonment. And really, they gave me 2 weeks. By the time that all this time, the 4 months, whatnot, it had always been they insisted on $6,000 or you're not getting your car back. And so on December 3rd, like he said, Jeff said, they finally said, okay, we'll let you take the car back for $300 and some dollars. And that amount was not the same as the invoice amount. It was close, but it wasn't. But it just made me wonder what they were doing. And they gave me 2 weeks, but they didn't say they gave me 2 weeks. We were communicating and I was expecting them to communicate and to say, look, this has been 2 weeks, we're going to do it now, or you have this week to do it or whatnot. We're going to tow it. So I thought we were still in negotiation or just talking things through.
Okay.
But
we're repeating things that have already been said.
Okay, all right.
The case. So, all right. I think, I've heard the case. I understand the nature of the claim and the nature of the defense and the nature of the counterclaim. This is probably a good example of something that I do think that the parties could have resolved this probably along the way, even before it became a case in court. But, I come back to the, sort of the original principles. The plaintiff has the burden of proving their claim by a preponderance of the evidence, meaning the greater weight of the evidence. And I don't think that any reasonable person could believe that they could have a wrecked vehicle towed to a repair yard and then have it remain there for 4 or 5 months without that car being repaired, or if there's no, agreement or bargain to go ahead and repair it, to take it away to someplace else and have it worked on by somebody else. It's just not reasonable. No reasonable person would believe that they could leave a damaged car at a repair shop indefinitely like that. That's just not that's not what they're in business to do. That doesn't seem reasonable under any analysis. Even if you were talking with them, that doesn't mean that it's reasonable to expect that they would allow a damaged car to sit on their property completely free indefinitely. It just makes no sense. So a reasonable person would either have the vehicle repaired at that collision shop, or if they didn't think that that collision shop was qualified to do it, or they were too expensive or something like that, they would have that car taken to another place that was satisfactory to them. That's what a reasonable person would do. So I cannot believe and will not accept that there was an agreement on the part of Thurston County Collision to indefinitely retain this car at no cost, and at the same time not be actively working on repairing it. So any reasonable business owner with a vehicle on their property that was not being worked on as part of their business, they would have it towed away or have it removed in some way because it's on their property for no productive reason. I saw in the exhibits that Summit Towing was the impounder that they work with. There were signs up, notice was provided. Ms. Vu is very clear that she's not particularly diligent about collecting her notices, and that might explain why the vehicle was towed away, and that the subsequent notice of right to an impound was not acted on in a timely way. So I just cannot award any damages based on that transaction. The behavior that Thurston County Collision engaged in there was perfectly reasonable. They just weren't going to retain this vehicle indefinitely. As far as damages, I mean, if they had wrongfully had that vehicle towed away and disposed of, they would owe you some damages for that. But they didn't. They provided notice. They said, come get it or we're going to have it towed away. That's exactly what happened. If you believe that Summit Towing did something wrong, you would have exercised your rights under the impound statute and challenged that tow as wrongful and potentially been entitled to damages there. But you're not. You didn't exercise that. So on the underlying claim, there'll be no damages awarded. As far as the counterclaim, I know there was a counterclaim made for $6,475.26. It's not entirely clear to me what that's based on. I know that it would be reasonable that Thurston County Collision would incur some costs for having over a period of time that lengthy, which they did, but it also doesn't appear that Thurston County Collision undertook to repair the car or procure any parts or anything, or incur any expenses related to attempting to repair the car. So I think it would be reasonable under the circumstances here to award some amount for the time that the Thurston County Collision retained the car for the convenience of Ms. Vu. And I think a reasonable amount for that would be $500. So I will award no damages on the underlying claim. I will award $500 in damages on the counterclaim. And there were no filing fee for the counterclaim. And Mr. LaCroix, did you have to pay the process server to serve the counterclaim on Ms. Vu?
Yes, $120.
120, all right, that's a reasonable and common amount. So the Amount awarded under the counterclaim will be a total of $620.
So, Your Honor, even though it was not valid service.
No, I'm finding that the service was valid based on the declaration of service that was filed. It was also timely under the small claims filing rules. All right, I'm writing a judgment to the effect of my oral ruling, filing that judgment with the court clerk, and it'll be available to both of you from the court clerk's office at any time. All right, that will conclude the case for today.
Thank you.
Thank you, Your Honor.
Well, you know, I often say I like to have a cautionary tale or two. We had a whole big show full of them today, ladies and gentlemen. One of the big takeaways is don't think that you can get your car towed to a repair shop and let it just sit there as a storage spot while you can go off gallivanting around the world or doing whatever life requires of you. Your car is not the safe storage spot at a repair shop. And if you didn't know that before today, now you do. And the perils for that are quite clearly get your car just towed, sold off, and another good one in that whole entourage of lessons right there is check your mail. Right? I'm the world's worst about this, but yeah, you definitely want to check your mail. Mama Wolfie is asking if we're gonna have a premiere tonight. The answer to that is absolute 100% yes. I think we still have some a Family Feud with Hestlink that hadn't been seen. I got some suppression stuff with Judge Webster that we haven't seen. I'm pretty sure I have some Judge Mogan hanging around here someplace that we haven't seen. And I'm going to pick something out of that big old lot. I'm trying to think. Oh yeah. We got a Judge Mogan that's about an hour and 10 minutes long from this past week where an inmate who's jailed is very upset that he's in the same jail with his son. We might have to check that one out. Ladies and gentlemen, stay tuned if you're not already licensed and subscribed. Go ahead and do that. And in the meantime, I'm going to go over here and I'm going to hit this little button. I'm going to say thank you very much to my dear friends, especially Zach and Clark. Oh my God, guy. Love you, guy. He's one of the best creators on CourtTube right now. Court Short, Law Nerds Unite. He is the brains behind all of them. Kind of like Hutch is the brains behind, what is it? Sovereign Legal Encounter? I can never get that channel name. And I go there like every single day and I just never get it right. That's not saying much. I can't get my channel name right But we had a big day and we started off with civil, went with a little bit of criminal, ended with another civil. That first case for Monday. Oh, Lord. Mondays in Thurston County are always good. And I had to throw in the competency update because at least two of those people in that little competency update that we saw there were repeats that we've seen, not necessarily with Judge Stillwell, but Judge Buckley at one point. Judge Wohl at another, I believe. But for now, ladies and gentlemen, I'm going to say thank you. I'm your Lone Wolf Usul. I'm the guy who puts together all of these videos from CourtTube into these little compilations. And I thank you very much for hanging out with me. I am out. There's a lot of people in chat talking about how they cannot type. Man, let me tell you about somebody who cannot type. You have seen me try and type plenty of times, and I mess it up. I actually make these videos quite often with, spelling snafus. And you would think putting the video together, you might spell check things every now and then. No, can't do that. That would be like asking for directions when you're lost. No, can't do that. But you can go enjoy some Ferris Bueller's Day Off now that we're done here. Bye. I just got to show you something. Mama knows proofreading is not Lone Wolf's forte. See that right there? Mama knows. Yeah. Them's the facts. See ya.